Hello and welcome to another episode of the in-depth series. The executive and the judiciary are at crossroads again. This is all because of the delay that has been occurring in the appointment of judges, and it is not sitting well with the executive, saying that if you did not thwart NJAC, National Judicial Appointment Commission, then we would have been at a different place. So we are going to discuss it from the perspective of GS Mains Paper 2nd and also from the perspective of preliminary examination. These are the many topics we are going to discuss. The government or the executive has resentment towards the Collegium System of appointments through which judges of the Supreme Court and the respective High Courts are appointed and transferred. And executive has given the statements to have a say in the appointment procedure, calling that Collegium system has no accountability. Also, there are grievances against the invalidation of the National Judicial Appointments Commission that could have been introduced in 2015 through an amendment of 2014, but it was struck down as unconstitutional by the Supreme Court. The government goes on to say that the Supreme Court is preoccupied with making appointments when their primary objective of their existence is to deliver justice. And there is a lack of accountability as well as transparency in the Collegium system. The government should work with a sense of constitutional statesmanship rather than find fault with each other. This has been said by the Supreme Court, also saying that the Supreme Court has taken cognizance of the government sitting on Collegium recommendation for years together for undisclosed region. So both the parties are throwing mud at each other without any solution. That is what we are going to discuss today. First of all, we have to understand what is the Collegium system. See, Collegium system is not provided for in the Constitution, neither it is given by any act of the Parliament. It has evolved through years and years of hearing of cases, as we know them, the three judges case. The three judges case gave birth to the Collegium system. It is a system of appointment and transfer of judges. It has evolved through the judgments of the Supreme Court. Basically, this is a small clique of the Chief Justice of India plus 4 other senior most judges. This clique works in consensus to make appointment and transfer of judges. Let's know about the evolution. The first judge's case, or the S.P. Gupta case, very famous case in 1981, gave an upper hand to the executive over the judiciary. Let's know how. In the first judge's case, the Supreme Court said that the primacy or the preference of the Chief Justice of India's recommendation on judicial appointment and transfer can be refused for cogent reasons. That means if the executive feels so that the CJI's opinion is not suitable, then it could be refused, and this helped the executive to remain dominant in the transfer as well as appointment for the next 12 years. This was in 1981, the S.P. Gupta case, or the first judge's case. Then the second one was 1993. In 1993, the second judge's case. Here, the birth of Collegium system occurred. Collegium system, in that it meant that holding consultation really meant concurrence. Consultation does not mean disagreement. It means concurrence. You have to get to an agreement point. And it's not that the CJI's individual opinion is important, but his opinion or her opinion along with 2 senior most judges in the Supreme Court. Then comes the third judge's case. Here, on the precedent's reference under Article 143, the Supreme Court expanded the Collegium to a 5-member body in which we have the CJI, the Chief Justice of India, and the 4 senior most judges. Alright, so remember that it was expanded in the third judge's case. Moving on. Now it is headed by the Chief Justice of India, the Collegium, plus there are 4 other senior most judges. Judges of higher judiciary are appointed only through the Collegium system, and the government has a role after the names have been decided by the Collegium. Now this is the problem, the second and the second point entirely. See, Collegium system works in a very opaque manner. So first criticism is it is opaque. Secondly, it does not have any set of criteria on which or with the help of which it can appoint judges. Okay, so it does not have any criteria that there are tick boxes on marking of which we can appoint or transfer the judges. Third, nepotism and favoritism can also arise because of the sheer opaqueness. Because it is not having any set criteria, it is a small clique of known people. So there can be an incident where only favorites and family members are appointed because it is opaque. And fourth, because of not a time period that has been specified to appoint the judges, the collegium has been called non-accountable because there is no stipulated time, there is no criteria. So in case a person who is not fit to be a judge has been appointed, who has the accountability for that? The collegium doesn't. So these are the criticisms. Right now, the memorandum of procedure, they dictate the appointments and the transfers. And it was introduced in 1997 only to be updated in 1999. Right now, we are mandated by MOP 1999. Although in 2017, the new MOP was finalized but not adopted by the government, saying that it was reconsidering this issue. Moving ahead, first of all, let us know about the Supreme Court judges, how they are appointed. See, clause 2nd of Article 124 of the Constitution of India calls for the appointment of judges, and the appointment is done by the President under his hand and warrant and seal. When a vacancy for a post of the Supreme Court judge arises, the Chief Justice of India sends his recommendation to the Union Minister of Law, Justice and Company Affairs. Okay, so first that. Secondly, we have to understand over here, when do we decide it? 6 months prior. If there is a known fact that these amount of judges are going to be retired from this day onwards, then from that date, you have to go back to 6 months and start your process. Then the CJI decides on the recommendation in consultation with the collegium. Whatever the consultation is there, it should be recorded in a written manner. Opinions from other judges are also there, but it does not need to be recorded in a written manner. Although the essence or any issues if they have, it can be conveyed to the executive. The Union Law Minister presents the CJI's final recommendation to the Prime Minister. Then the Prime Minister recommends it or forwards it to the President, and then the judges are appointed. After the appointment has been done, Secretary to the Government of India in the Department of Justice informs the CJI that this person has been appointed, and then it also obtains a certificate. The Secretary also obtains a certificate of physical fitness from the appointed judge, which is signed by the Civil Surgeon or District Medical Officer. And then the appointment is announced by the Secretary once the warrant of appointment is signed by the President of India. Then it is notified in the Gazette of India. So this is the process. Alright, I hope it is crystal clear. Let's talk about National Judicial Appointment Commission. What is this? Why did the government want this particular commission? See, in August 2014, the Parliament passed the bills, the Constitution 99th Amendment Act of 2014, through which NJAC could come into existence. Okay, and the first one, that second one is this. And through it only, an independent commission could be formulated to appoint judges to the Supreme as well as the High Court. These bills were ratified by the required number of state legislatures. They were also fine with it. Got the precedence sent on 31st December 2014. Here, the composition of the NJAC could be Chief Justice of India as the ex officio chairperson, 2 senior most Supreme Court judges as ex officio members, Union Minister of Law and Justice as ex officio members, 2 eminent persons from civil society to be nominated by a committee. Here comes the executive. Okay, this 2 persons from the civil society plus Union Minister of Law, this is the executive part, because of which the judiciary was not happy, because it was seen that this NJAC could dilute the monopoly or the independence, I should say, of the judiciary. See, 2 eminent persons from civil society to be nominated by a committee. Chief Justice of India is the person that is in this committee, plus the Prime Minister of India, and then the leader of the opposition of the Lok Sabha. and also one of the eminent person to be nominated from SC, ST, OBC, minorities or women to be a part of this NJAC. Okay, so these all were the concomitants. Okay, now the Chief Justice of India and Chief Justice of High Courts were to be recommended by the NJAC, which was to be based on seniority, while Supreme Court and High Court judges were to be recommended on the basis of merit, ability and other criteria specified in the regulation. This is very subjective, but still, because of so many people in this NJAC, it could have been scrutinized. The person could have gone through a much better scrutiny. The Act empowered any two members of the NJAC to veto a recommendation if they did not agree with it. That means the independence of the judiciary could have been impacted. So it was struck down on the basis of unconstitutionality and invalidity. So in 2015, the Supreme Court Advocates on Record Association, they petitioned against NJAC, saying that it is unconstitutional and invalid. Because 99th Amendment provides for the creation of NJAC, they took away the primacy of the collective opinion of the Chief Justice and the senior most judges. That was the collegium which they thought had to be protected, because after so many issues, the collegium came into existence. So second problem was that this NJAC severely damaged the basic structure of the constitution. Two things are there: the independence of the judiciary. It stems from Article 50 of the Indian Constitution, which is the DPSP, Directive Principles of State Policy. The principle of independence say that judiciary has to be derived from the theory of separation of powers. Independence is a must. There should be checks and balances. Dr. Ambedkar said that, who was the chairman of the drafting committee, said that there can be no difference of opinion in the House, that our judiciary must both be independent and of the executive and must also be competent in itself. So B.R. Ambedkar had this vision. Now through NJAC, executive was coming into the picture of the judiciary. The basic structure doctrine was, of course, declared in the Kesavananda Bharati case of 1973, in which Article 368 grants Parliament a virtual plenary power to amend the Constitution, but the bench had held that the Constitution should not and could never be amended in which the basic structure is threatened, and independence of the judiciary is one of the basic structure features, although it is not given anywhere. It was also said that this NJAC was void and ultra-vires the Constitution as it was passed in both the houses of the Parliament when Articles 124 Clause 2 and 217 Clause 1 as originally enacted were in force. So if there was already an appointment process, why to ultra-vire the Constitution? So there are certain allegations that the executive makes on the judiciary, saying that the collegiums, both at the Supreme Court and the High Court, they are delaying judicial appointments, and the NJAC was a good law that was thwarted by the Supreme Court. High courts are not making recommendations 6 months in advance, and that is causing pendency. As of November 30th, you do not need to remember the data, just get an idea. As on November 30th, 2022, there are 332 judicial vacancies in High Courts out of a total sanctioned strength of 1108 judges. The High Courts have made 146 recommendations which are under consideration of the government and the Supreme Court. 43 High Court judges are scheduled to retire between December 1st, 2022 and May 31, 2023, which will take the vacancies up to 229. And then the Supreme Court rejects 25% of the names which are recommended by the High Courts for judgeship. How will that help according to the executive? The delay in the appointment process has affected the timely filling up of vacancies in the High Courts. The Supreme Court itself has 6 vacancies. Recently, the 28th judge of the Supreme Court, Justice Dipankar Datta, was sworn in. And of course, we need 34 judges. 1 judge plus a CJI plus 33 other judges. So we are in a shortage of that. So this is the problem. Supreme Court has responded by saying the government has either kept collegium recommendation pending for no apparent reason, or it is not appointing the persons who are not palatable to it. So both these sides are really at crossroads. One thing that we need to understand over here is to create a structure through which we can solve the eventual problem, reduce pendency of cases, deliver justice, and then of course ensure that people of ability make it up to judgeship and not through an opaque system. So these are the criteria, these are the issues that we need to resolve together. A question will be attached to the comment segment for which you have to answer. And let me take the names of those who have answered my last question correctly. The correct answer was B. Karishma, Rupal, Aditya, Daksha, Anuj, also Yash Lohar, Priyanka, Ashish, Sagar, Richa, Pallavi, Supriya, Akash, Rehan, Tushita, Puneet, Rahul, Sagarika, Koil and Sharva. You all have answered it correctly. Thank you so much for watching.